is the presumption of innocence, and what does it mean for something to be proven beyond a reasonable doubt? Let's talk about that. Hi, I'm Joel Chorny. I'm a criminal defense attorney in Tucson, Arizona, and I'm wearing my weekend gear right now. So that's why you got bananas on my shirt. And I was thinking about what to talk about in my next video, and it occurred to me that it's a ripe topic of conversation to discuss what the presumption of innocence means and what proof beyond a reasonable doubt means. Presumption of innocence is exactly that. We presume that a person who's accused of a crime is innocent until it is proven beyond a reasonable doubt that they're not. I often have said to juries in trials that it's not really the defendant who is on trial. And that often gets a surprised look from people because really the party that's on trial is the government, the state, the prosecuting body that is bringing the accusations against the defendant. The jury's job is to judge the government and whether or not they met their burden of proof beyond a reasonable doubt that the defendant is in fact guilty. And if they failed to do so, then the presumption of innocence holds, and the defendant who started the trial as an innocent person finishes the trial as an innocent person, and the jury is expected to return a verdict of not guilty. So basically, the presumption of innocence is a rule that says that we don't punish people for having broken the law in a criminal sense unless it is proven beyond a reasonable doubt that they are in fact guilty. Now, a defendant can convict themselves by pleading guilty, by admitting guilt, and basically waiving his or her right to force the government to prove their guilt beyond a reasonable doubt. That's what happens with plea agreements, for example, which are the most common way that criminal matters are resolved here in the United States. So the presumption of innocence is one of the most, if not the most important principles of our criminal system. Unlike the presumption of innocence, which is pretty straightforward to understand, then there's this idea of proof beyond a reasonable doubt. And what is proof beyond a reasonable doubt? So in our legal system here in the United States, we have several different levels of proof, burdens of proof, if you will. What I explain to juries in closing arguments in my trials is that proof beyond a reasonable doubt is the highest burden of proof in our legal system. Compare that to the lowest burden of proof, which is reasonable suspicion. Reasonable suspicion is the burden of proof that a police officer needs in order to pull someone over in traffic, for example, or in order to stop them and ask them some questions, maybe even frisk them, do what's called a Terry frisk on the outside of their clothing, looking for weapons and contraband. Reasonable suspicion is the suspicion that allows an officer to reasonably articulate their reasons why they suspect that a person is breaking the law and or in possession of contraband or evidence of a crime. And it's a very low burden of proof. The officer can be completely wrong about it. They're allowed to be mistaken, and it doesn't require a whole lot. It has to be reasonable, and it has to be articulable. The officer has to be able to explain what it is that made them suspect the person in the first place before they would stop that person from going about their business. That's reasonable suspicion. Above that, you've got probable cause. Probable cause is the burden of proof that is required to arrest someone, to put them in handcuffs, to restrict their movement in a more significant way, and also to bring charges. So you will likely have heard the term a grand jury. A grand jury is a body of citizens that meets in secret behind closed doors, considers evidence that is presented by the prosecution, and determines whether or not the prosecution has enough evidence for there to be probable cause to proceed with the charges against the intended defendant. Probable cause is also a very low burden. The way I explain probable cause is that it is a fair probability, a fair possibility that the person is in fact guilty of what they are being accused of. So it doesn't even have to be a huge probability. It just has to be a fair probability. There's no distinct number that is associated with that, but I can tell you that it is less than 50% because the next burden of proof that I want to talk about is preponderance of the evidence. Preponderance of the evidence means more likely than not. It's the burden of proof that a party in a civil action needs to meet in order to win the civil suit. So if you think of a lawsuit as being a dispute between two parties, one party saying you did something wrong, you need to pay me, and the other party saying nuh-uh, they would present evidence at the trial, and then the jury, or if it's a bench trial, the judge, however it works, whoever the fact finder is, would have to decide who presented stronger evidence, who's more likely and not the one party that is correct. It's really a weighing test. And so even if it's 50.1% likely that one side prevails over the other, that party wins. It's called preponderance of the evidence. It is a higher burden of proof than probable cause, but it is a significantly lower burden of proof than proof beyond a reasonable doubt. I explained that even before you get to proof beyond a reasonable doubt, there is a burden of proof called clear and convincing evidence, which is hard to quantify. We know it's greater than preponderance, and we know that it's less than proof beyond a reasonable doubt, but we don't have percentages associated with it. And it's basically enough proof that leaves the fact finder clearly convinced that the answer is what it is. I find it is easier to explain what this burden of proof is by explaining what it applies to. And so here in Arizona, the clear and convincing standard is the standard that the government needs to meet, has to prove in order to take a person's children away from them and to say that a person is not a fit parent and can no longer have custody of their children. The government has to prove that by clear and convincing evidence. It's a very high burden, very serious situation that that burden applies to. And even then, that is below proof beyond a reasonable doubt. Proof beyond a reasonable doubt, like I said earlier, is the highest burden of proof in our legal system. And there are no percentages associated with it, kind of by design. What I tell juries is that it's not even accurate to say it's 90%. It might not even, it could be less, it could be more. It's not really how it works. Here in Arizona, we have an instruction called the Portillo instruction, and it's called that because it comes from a case called State v. Portillo. And it's an interesting instruction because it has two parts. And what I have found in my years of practice is that the prosecution will emphasize one part and the defense will emphasize the other part, but they're both parts of the same whole. So what I'm going to do is I'm going to read you that instruction and I'm going to explain how it works. So that instruction reads like this. It says, the state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. That is not the part that gets emphasized by either side, actually. Moving on to the next paragraph. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him or her guilty. If, on the other hand, you think there is a real possibility that he or she is not guilty, you must give him or her the benefit of the doubt and find him or her not guilty. So the part that the prosecution always emphasizes is that the law does not require proof that overcomes every doubt, and that if, after you've considered the evidence, you are firmly convinced that the defendant is guilty of the crime charge, you must find him or her guilty. That's the part the prosecution likes to emphasize because it's lowering their burden. Not really because their burden is their burden, but it's telling the jury, hey, we don't have to convince you beyond all doubt. Now, I think this is humorous because the jury gets to decide whether or not they have doubts in their minds, and no one will ever question the jury as to whether or not their doubts were reasonable. If the jury determines that they have doubts, even if objectively there were some way of being able to assess whether or not their doubts were reasonable or not reasonable, at the end of the day, if they decide to acquit the person because they have doubts, that's it. There's no appeal. There's no way to reverse that. So really, this idea that they should only acquit if they have reasonable doubts is kind of a silly one because they get to decide whether their doubts are reasonable or not. So I think that we have created a scheme that really confuses the issue. Ultimately, the way I see it, if the jury believes that there is a fair possibility, and this gets to the part of the instruction that defense attorneys tend to emphasize, that last part, if the jury believes that there's a fair possibility in light of the evidence that's been presented that the defendant is not guilty, they are obligated to find the defendant not guilty. So what I tell jurors is that even even if you think it is extremely likely that the defendant committed the crime that they are being accused of, if based on the evidence as it stands, it is still possible that they did not, you're supposed to acquit. Now, that seems pretty straightforward to me, but for some reason, juries really struggle with this. The last trial I had, if you've watched my previous videos, you'll know I hung that last trial, and we had a split of 8-4, 8 for acquittal, 4 for conviction. And the 8 who were there for acquittal, they really got it. I spoke with the jury afterwards, and they got that they just felt like the state had not proven beyond a reasonable doubt that my client had committed the crimes he was accused of. They felt that the evidence could still leave the possibility of his innocence on the table. The last 4, in my opinion, they didn't follow the law. They listened to the alleged victim say that things happened, and they ignored a bunch of evidence that called the alleged victim's claim into question. And so they wanted to convict from the beginning. I think that if people took this instruction at face value and as seriously as I do, it would be very hard for the government to be able to overcome the presumption of innocence. But that's a good thing, because we want to err on the side of not incarcerating innocent people. And that is a real danger. We know that people have been wrongfully convicted. Unfortunately, we know that we have, as a society, executed people who didn't do what they were accused of. We really need to be careful to not take a person's liberty away unless there's sufficient proof that they deserve it. And frankly, I think that a lot of times juries don't get that, and they give the prosecution a pass because they are overcome by the emotion of the case and because they don't appreciate that the evil of convicting someone who didn't do the offense is so much greater than the evil of letting someone who did do the thing walk or go free. So anyway, that is, in a large nutshell, my explanation of what proof beyond a reasonable doubt means and what the presumption of innocence means. If you have any questions, or if you are surprised by what I've just said, or you have experience in applying these burdens, drop it in the comment. I'd love to see what you have to say about it. If you found this interesting and know someone else who would as well, share the video. I'm trying to build a following here. If you have any ideas for other videos, topics that you'd like me to discuss, please drop those in the comments as well, as I would love to be making videos that you find interesting. Until next time, remember, your rights are important. They matter. Protect them. Be safe, and I'll catch you on the next video.